You see that whenever we talk about uh, the Indian Constitution as such, basically when we talk about the development which took place with respect to the framing of the Constitution, generally we talk about the era of the British government, the laws which were enacted by the British Parliament from time to time. But that is the domain of our history teacher, and the history teacher will help you in understanding that how the British ruled us, what were the laws that were framed by the British Parliament, that is the Government of India Acts, which were framed from time to time. And not only this, the history teacher will help you in fighting for your independence, and also to we can say he will help you in getting independence also. And after that my work starts. So your history teacher will be discussing with you the constitutional developments, that is the Government of India Acts which were passed from time to time. And after we got independence, that is our work starts, means the polity section starts. And here basically if we talk about the framing of the Constitution, I have written here that the Constituent Assembly, it had framed the Constitution of India. Now basically it is a story, that is how the Constitution was made, how it was enacted. You see, the Constituent Assembly was not elected by the citizens of India on the basis of universal adult suffrage. And basically the Government of India Act 1935 had provided for the elections to the we can say the provincial assemblies. And if you have read history, you may be knowing that in 1935 the elections for the provincial assemblies had taken place. There were provincial assemblies, and the members of the provincial assemblies, they had taken part in the election of the members of the Constituent Assembly. So the members of the Constituent Assembly were not directly elected by the people, but the members of the provincial assemblies, just as in the modern times we elect the members of the Rajya Sabha, that is our MLAs, they elect our representatives. Similarly, from Bombay, the members of the Bombay Provincial Assembly, they elected their representatives. From Mysore, Madras, they elected their representatives. Sorry, from Madras, from Bengal, from United Provinces, Central Provinces, the members of the provincial assemblies, they elected their representatives. And then the princely states had to nominate members. But basically you see that this is one of the criticisms of the Constituent Assembly, that the Constituent Assembly was not a true representative of the people of India, because the members of the Constituent Assembly were not directly elected by the people of India. And no doubt the members of the provincial assemblies, they were elected by the people, but there was limited franchise. Franchise means the right to vote. All the people were not given the right to vote by the British. So your history teacher will tell you in a more detailed manner all these aspects. No doubt these members had resigned in 1937, but their names were there, that okay, these persons have been elected from Bombay, these persons have been elected from Bengal, these persons have been elected from these are the, so these people, they elected their representatives. I will be coming to this debate after some times. Now during the elections, what we saw was that the Congress, no doubt it was the dominant party, but it tried to include all the sections of the society in the Constituent Assembly. For example, Dr. B.R. Ambedkar. Dr. B.R. Ambedkar, he was not a congressman. He had resigned from the Congress because he had ideological differences with Mahatma Gandhi. But the Congress ensured that he should get elected to the Constituent Assembly. You see, he did not contest the elections from Bombay, but he filed his nomination paper from Bengal. So he represented Bengal in the Constituent Assembly. Then another name, Dr. Shyama Prasad Mukherjee. Dr. Shyama Prasad Mukherjee was a right-wing leader. Right-wing group was there, that is called Jan Sangh. And Jan Sangh later on became the Bharatiya Janata Party. And Jan Sangh was a right-wing ideological group. What is left-wing and right-wing? You see, leftists are those who want a radical restructuring of the system. They want radical restructuring, a change in the system. And when we talk about the rightists, they aim to preserve the status quo. And that is why the Bharatiya Janata Party is termed as a rightist political party. It wants to preserve the status quo, the culture, the tradition, the customs of the society. That is what is prevailing now. The leftists, they want a radical restructuring of the system. So, you see that when Dr. Shyama Prasad Mukherjee filed the nomination paper, then the Congress ensured that Dr. Shyama Prasad Mukherjee should also get elected to the Constituent Assembly. And he got elected also. Now, if you are asked this question, that do you think that the Constituent Assembly was not a true representative of the people of India, then it is not that you should say, yes, yes, sir, it was not a true representative of the people of India. Otherwise, your result will be declared on that day only. What will be the result? It will be a negative result, because the candidate who has no faith in the Constituent Assembly, how he will have a faith in the Constitution? How he will administer this country in accordance with this Constitution? So, you need to answer this question in a very positive way. You should say that, sir, some historians are of the view that the Constituent Assembly was not the true representative of the people of India. So, it is not your view, it is the views of some of the historians. So, some of the historians are of the view that the Constituent Assembly was not the true representative of the people of India. Generally, sir, they have taken into consideration the aspect that the members of the Constituent Assembly were not elected by the people of India in direct elections. There was no universal adult suffrage, but they were elected by the members of the provincial assemblies. And the members of the provincial assemblies, they were also not elected by the universal adult suffrage. All the people were not given the right to vote. There was, we can say, limited franchise. So that is why it can be the view. But on the other hand, if we see the composition of the Constituent Assembly, the members of the Constituent Assembly, they were from different parts of the country. The south, north, east, west, central, northeast, every part was represented. The people of all the groups, all the religious groups, they were there. The people of all the caste groups, they were there. And sir, every section of the society was represented, and the downtrodden were represented by none other than Dr. B.R. Ambedkar. People of different ideologies were also represented. The socialists were represented by Pandit Nehru. Then the rightists were represented by Dr. Shyama Prasad Mukherjee. So basically, if we analyze, because you see, knowledge of history and understanding of history, these are two different things. So we need to have an understanding of history. Then only you will be able to answer the questions in a proper way. Now, after the elections took place, it was a body which was dominated by the Congress, and when the first session took place, the Muslim League demanded a separate Constituent Assembly for Pakistan. It boycotted the Constituent Assembly, and our leaders tried to talk to them, but the leaders of the Muslim League, but it was useless. But we were focused from day one, and what our Constituent Assembly did, we constituted 22 committees to give inputs on various aspects. Now, another important thing regarding the Constituent Assembly was that the Constituent Assembly was based on consensus. It is one of the most important aspects. That is, it was based on consensus. Now, how this consensus used to be arrived at, that you need to understand. Because in the book, it is only one sentence that can be written, that the Constituent Assembly was based on consensus. But how this consensus was created? You see that discussion and debates used to take place in the Constituent Assembly on each and every part. So, when the first draft was prepared, the rough draft, then the part-wise discussion used to take place in the Constituent Assembly, and the members used to discuss it, and after the discussion, there used to be voting on the particular part or the chapter. Now, when Dr. Rajendra Prasad used to say that some of the members of the Constituent Assembly, they will not vote in favor of that particular part, particular article of the Constitution, then he did not allow voting on that day. He used to adjourn the meetings for that day, that the meetings of the assembly stands adjourned today, the assembly will meet tomorrow at this time. No voting on that day. So, after the formal meeting used to be over for that date, now you see the dedication of our constitution makers. It is not just numbers 1, 2, 3, 4, 5, 6. How these numbers were written, how these articles were incorporated, that is very important for us to understand. So, after that, the members used to meet again. The meetings of the Constituent Assembly used to take place in the central hall of the Parliament. That is the old Parliament, we can say. That is why it has been termed, it has been named as Samvidhan Sadan. It has been named as Samvidhan Sadan. So, in the central hall of the old Parliament, the meetings used to take place. Now, after the formal meeting used to end on a particular day without voting, then what the members used to do, they used to meet again informally, not at that place, but at some other place, and they used to discuss that aspect on which the consensus was not arrived at and some members were opposing it. So, informal meeting used to take place. The members used to speak their mind, that why we are against this particular article of this article of this part, and what changes we want here. So, there used to be deliberations for 3 hours, 4 hours. Now, you see the dedication of our constitution makers. For the whole day, they used to sit in the Constituent Assembly, and after the formal meeting used to be over, after 1 or 2 hours, they used to meet again, and they used to discuss the aspect again on which there was lack of consensus. And after the consensus was arrived at in the informal meeting, they used to go, and then they used to submit, we can say, report, we can say, to the presiding officer that, sir, everything is, we can say, tomorrow we will have the discussion again and we will be moving some amendments there. And after that, the amendments used to be moved, and that is the rationality, because discussion used to take, there was no ego there among the members. Now, You will say that, sir, what was the need of all this type of drama? Let the majority view would have prevailed there. But you see that the whole world was observing the framing of the Constitution of India, that is the would-be largest democracy of the world. And it were not the Indians who were sitting in the visitors gallery, but the people from different parts of the world, they were also sitting and observing that how the Indian Constitution was being made. And because the British were of the opinion that India will never be able to have their own constitution because of the diversity that is there. So that is why the eminent scholars of the world were sitting, they used to observe and used to write. And what the message would have gone, that this constitution is an imposition on the group, on the minority groups. So you see that this aspect, and after that again the discussion and again the voting used to take place. So our constitution was based on consensus. This observation that I told you is not, we can say, the glorification of Indian constitution making as a nationalist, but this has been written down in a book written, the most, we can say, one of the most famous books which have been written on the framing of the Indian constitution. The book is by Granville Austin, and the book is The Constitution of India, the Cornerstone of the Nation. And in that book he has described topic wise that who said what type of discussion used to take place in the Constituent Assembly with respect to the framing of the constitution. So it is not an account of an Indian who was sitting there, it is an account of a foreigner who was sitting there. In graduation we asked the students to read this book also, that is Granville Austin's book. Obviously in the competitive examinations they have made a fashion to tell Lakshmikant's book, but yes, you will not get an insight about the things, you will get a, we can say, knowledge from above, but the deep insight. So here the one sentence that we need to remember is that the Indian constitution was based on consensus. So if you develop such type of understanding, then in the preliminary examination it is not that you will have to mug up that Indian constitution was based on consensus and you will have to underline the sentence in the book. Oh, the teacher had discussed it in the class, because there is always a hearing impact in the examination. So the Indian constitution was based on consensus. After that, our constitution was ready on 26th of November 1949. Some of the provisions of the constitution, they came into force from that day also, but rest of the provisions of the constitution, they came into force from 26th of January 1950. What is the relevance of 26th January 1950? Why this date was chosen? Jawaharlal Nehru had passed a what type of resolution he had passed? So a person will pass a resolution or he will present a resolution. No, I told you that on 26 January 1950, the constitution came into force. But why that date was chosen? Why that date 26 January was chosen, not any other date? Because in the Lahore Congress, the Congress had passed a resolution for Purna Swaraj. So to commemorate that day, the 26th January is observed as the Republic Day. Then another important thing, the basic thing that you need to know, why this day is observed as Republic Day, not as a Constitution Day, not as a Constitution Day. Why Republic Day? 26 January is Republic Day. Why Republic Day? Why not Constitution Day? After the NDA came to power, it started observing 26th November as the Constitution Day. But before that there was no Constitution Day. So when the Constitution came into force from that day, so why not Constitution Day? Why Republic Day? Do you know what is the meaning of Republic? The head of the state is an elected one. So on 26th of January 1950, Dr. Rajendra Prasad had taken oath as the President of India. Before that, we had the Governor General, who was not an elected one. So from 26th January 1950, India was declared as a republic. Why? Because our head of the state, that is the President, was an elected one. That is why it is Republic Day. So you need to have, we can say, very much clarity about the fundamental things. Because if you know all the articles and if you don't know the basic things, obviously there is no use of it. You can read lot of political science, but the basic things, why this day is observed as the Republic Day, why not the Constitution Day? This story that I told you is important from the prelims point of view. Some of the facts I will tell you, you can write it in points आप लिख लो. The elections to elect the members of the Constituent Assembly, the elections to elect the members of the Constituent Assembly was held in July 1946. In July 1946, full stop. The members of the Constituent Assembly were elected by the members of the Constituent Assembly were elected by the members of the provincial assemblies. The members of the provincial assemblies. Full stop. The first session, a point wise, the first session of the Constituent Assembly was held on 9th December 1946. It was presided over by Dr. Sachidanand Sinha. The public service commissions are very fond of asking this name in the examination, that who was the temporary president of the Constituent Assembly. So he was Dr. Sachidanand Sinha. Full stop. The Muslim League boycotted the session. The Muslim League boycotted the session and demanded a separate Constituent Assembly for Pakistan. Next, on 11th December 1946, Dr. Rajendra Prasad was elected as the President of the Constituent Assembly. The President of the Constituent Assembly. Full stop. Sir B. N. Rao, Sir B. N. Rao, RAU, was appointed as Sir B. N. Rao was appointed as the legal or constitutional advisor, the legal or constitutional advisor to the Constituent Assembly, to the Constituent Assembly. So he was not a member of the Constituent Assembly, but he was the legal advisor, and he was the man who really worked behind the framing of the Constitution. He was the person who had gone through almost all the constitutions which were prevailing at that point of time, and he used to give advice. He is an unsung hero of the Constituent Assembly. Then next point you can write, on 13th December 1946, on 13th December 1946, Pandit Nehru presented the objective resolution, in the Constituent Assembly. In the Constituent Assembly. Now, what was that objective resolution? As the name suggests, objective resolution, that what is the objective of this Constituent Assembly? So, and this objective resolution basically gave the guidelines, that is what type of constitution we are going to have, and at the end this objective resolution with modifications, it was made the preamble of the Constitution. It took the shape of the preamble. Then, so this is also very important sentence from the examination point of view, and this one statement, Sachidanand Sinha, this name is important, and this statement is important. Which of the following statement is correct? Dr. B.R. Ambedkar had presented the objective resolution, Pandit Nehru had presented the objective resolution, because the student who will not develop an understanding, for everything he will encircle Dr. B.R. Ambedkar when it comes to the Constitution, but it was Pandit Nehru who had presented the objective resolution. In your state PCS examination also, these questions are most often asked questions. Then next point you can write, the assembly constituted 22 committees. The assembly constituted 22 committees to give inputs on various aspects, In any of the textbooks that you are following, the name of the committees will be there and their chairpersons will be there. So you can, this is all a very, we can say, factual thing, so you can have an idea from there only. Next point you can write, the drafting committee was headed by Dr. B.R. Ambedkar. The drafting committee is considered to be the most important committee, because this drafting committee, it had framed the draft of the whole Constitution, how the parts, how the articles will be arranged. That was the work of the drafting committee. So it was headed by Dr. B.R. Ambedkar, as you have written. Other members were Alladi Krishna Swami Iyer, Alladi Krishna Swami Iyer, K.M. Munshi, Muhammad Sadullah, then N. Gopalaswamy, then B.L. Mittar, B.L. Mittar, लिख लो, K. Munshi, M-U-N-S-H-I. Now, when we talk about B.L. Mittar, he was replaced by N. Madhav Rao because he was not well. He was replaced by N. Madhav Rao. Then another member was D.P. Khaitan. So he had died. So he was replaced by T.T. Krishnamachari. So they were the members, the chairman and the members of the drafting committee. So in the examination, basically K. Munshi is the name which is often asked, that which of the following was a member of the drafting committee. So 1 and 2, 2 and 3, such type of questions can be there in the examination. Then in the next point you can write, the constitution was based on consensus. The constitution was based on consensus. Then next, the constitution was adopted by the Constituent Assembly on 26th November. कहीं बैठ जाओ. On 26th November 1949. From that day, some of the provisions came into force. These provisions are Articles 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392, 393 and 394. In bracket you can write as per Article 394. As per Article 394. So it is mentioned in Article 394 that the Constitution was adopted on 26th of November 1949, and from this date these articles will come into force. So it is mentioned in Article 394. That is what you have written here. So it is all constitutional, means it has been mentioned in the Constitution, and it was mentioned in Article 394 itself that the rest of the provisions will come into force from 26th of January 1950. जो लोग कॉन्स्टिट्यूशन नहीं पढ़े हैं ना, they will not have an idea. They will feel that okay, it was just done. No, it is mentioned in the Constitution itself that rest of the provisions will come into force from 26th of January 1950. लिख लो इसको भी in the next sentence. Rest of the provisions came into force from 26th January 1950. Full stop. On that day, the Constituent Assembly ceased to exist. Ceased, C-E-A-S-E-D, ceased to exist, and transformed itself into Provisional Parliament of India, until a new parliament was constituted in 1952. So you see, that is from 26 January 1950, this Constituent Assembly had ceased to exist. That no longer the Constituent Assembly will be there, it was dissolved. But the Constituent Assembly continued as the Parliament of India. So they said that no, we will not be enacting a new law now, but we will, a new provision here, but even if we will make a law, we will make it in accordance with this Constitution. And if any change will be there in the Constitution now, it will be as per Article 368 of the Constitution. And so if the statement is, or the question is, which body acted as the first Parliament of Independent India, the answer will be Constituent Assembly, because the elections, there is a first Parliament was constituted in 1952. So between that period, who will make laws for this country? So it was the Constituent Assembly, but it was termed as the Parliament of India. Then in the next sentence you can write 26th November is observed as Constitution Day. Full stop. The objective of observing this day is to imbibe imbibe the spirit of the Constitution, in the people. What is the spirit of the Constitution? Liberty, equality, justice, spirit of the Constitution. So that is the purpose. Such questions are asked in the preliminary examination, that which one of the following is the purpose of observing the Constitution Day. It is to imbibe the spirit of the Constitution. At least on that day, people will, we can say, the lectures will be conducted, the programs will be there, and then the people will develop, acha, this type of liberty, this type of equality, this type of justice is enshrined in the Constitution. Then in the next point you can write, at its commencement, the Constitution had 395 articles, divided into 22 parts and 8 schedules. I repeat, at its commencement, the Constitution had 395 articles, 22 parts and 8 schedules. Full stop. At present, it has approximately 485 articles, divided into 25 parts and 12 schedules. Now, why we have written approximately, I'll tell you the reason behind it. Now, as this is our foundation class, we are supposed to feel that you people know nothing. You know nothing. So, we start from the scratch, that is from the zero. Now, first of all, you need to develop some ideas with respect to the basic things about the Constitution itself. When we talk about the Constitution, the broader aspects are termed as parts, broader aspects. They are termed as parts. Part 1, Part 2, 3, 4, 4A, 5, like this. And first of all, the part comes, and after the part, the articles are there. So, within the parts, we have got the articles, that is the provisions of the Constitution. So, for example, part 1, articles 1, 2, 3, 4. Part 2, 5, 6, 7, 8, 9, 10, 11, like this. Now, till part 4A, we don't have any chapter. We have got the parts and then we have got the relevant articles. But when we talk about part 5 is multi-dimensional part, and part 5 is related to the union. And within the union, we have got the union executive, that is the president, the vice president, the council of ministers, attorney general. Then we have got the parliament, we have got the judiciary, supreme court, all will come under the union. So, here, as it is a multi-dimensional part, we have got the chapters. Chapter 1, it is the executive. And then we have the provisions with respect to the president, vice president, council of ministers, the articles are there. So, the parts which are multidimensional, they have got the chapters also, and after the chapter we have got the articles. Similarly, part 6, it deals with the state. So, the state executive, governor, then the state legislature, then the high court, subordinate courts, chapters are there. Chapter 1, 2, 3, 4. So, the multi-dimensional parts, they have got the chapters also, and after the chapter you have got the articles. So, in some of the parts we have directly the articles, in some of the parts we have the chapter, and after that we have the articles. Now, during our discussion, you will find certain numbers, that is the articles will be there. The numbers are like this, that you can come across. You will come across certain numbers. देखो, Article 1, Article 2, Article 3, Article 4. Some of the articles can be multi-dimensional, can be broader. Then there will be clauses in those articles. The clauses are written like this. If I say Article 19 clause 1, you need to write like this, okay? And the clauses can also be written like this. Our constitution makers have interchangeably used it. At some place it is mentioned like this, that is Article 67A or 67B, like this. It is an example I have told. Or we can say 69A, 69B, these are examples. So, if it is a small b, then basically it is a part, it is a clause, it is a part of article number 67 itself. These are not separate articles. So, it can be like this or it can be like this also. Here I have specifically mentioned why, because article 19 clause 1 is there. So, it can be article, it can be clause A also, just as I have mentioned here. So, clauses can be like this. So, if I say article 69 clause A, article 304 clause B, you need to write like this. But if I say article 19 clause 1 sub clause A, you need to write like this. It is a part of this article itself. These are not separate articles. These are the part of these articles only. Then if I say article 21A, capital A, you will find capital A, capital B, capital C, like this. So, in some of the articles you will find these numbers, capital A, capital B, capital C. Wherever it is mentioned as capital A, capital B, capital C, or here part 4A, capital A, it means that they were not there in the original constitution. They have been added by an amendment to the constitution. So, here you need to know the amendment numbers also wherever it is required. So, wherever you will see capital A, capital B, capital C, it means that they were added by an amendment to the constitution. They were not there in the original constitution. Suppose article 21, it is right to life. Article 21A, right to education. So, it is not a part of article 21, but if it is capital A, so here 304 clause B, it is a part of article 304 because it is a clause of this article, but it is a separate article. It is a separate article. So, when you count the articles, you count these numbers and those which are written in the capital letters. Then it comes around 384, 485. I have written approximately. in none of the examination, even in the school quizzes also, it is not asked that how many articles are there in the Constitution. Why? Because it keeps on changing. For example, you say that today I will say that there are 485 articles approximately. In the winter session, the Constitution is amended. 2 articles are repealed from it. 3 more articles can be added there. So the numbers will change. So the number keeps on changing. That is why such questions are not asked even in the school quizzes also. They can ask that how many articles were there in the original Constitution. But you can ask me a question that, sir, why not 395, 396, 397, 398? You see, and you can ask another question to me that, sir, why the articles, they have been incorporated in the specified places? You say, as far as possible, the articles basically which have been incorporated later on, they have been incorporated nearest to their theme, so that there will be coherency in the document. For example, if we talk about Article 21, Article 21 talks about right to life, and Article 21A, right to education. Right to education is required to make our life meaningful. So right to education is related to right to life. So after Article 21, we have got Article 21A, right to education. Similarly, if you talk about this 4A, fundamental duties, here fundamental rights, directive principles of state policy, and then 4A, fundamental duties. So correlation, that okay, rights of the people, the duties of the state and the duties of the citizens, correlated. कि चलो यहीं पे बता देते हैं कि what is the, for what are the, so here a new article 51A was added, because the last article of part 4 is article number 51. So 51A, क्यों? Because 52 से यहाँ executive starts. So the coherency, and you will have an understanding also. Okay, rights of the people, the duties are also there. They have to be read together, rights along with the duties. So that is the idea. So as far as possible, these things have been taken into consideration. Then another example, you see part 9 of the Constitution, that is the Panchayati Raj system. Then part 9A, municipal bodies. Then part 9B, cooperative societies. So 3 have been added together. There is no doubt it was by a separate amendment act that cooperative societies was added. But yes, they have been added systematically, because cooperative societies, they are also a step towards decentralization, just like the Panchayati Raj institutions and the municipal bodies. So this is the logic here. Basically, I wanted to tell you this aspect. So when in the class I will tell you, I will say article 304 clause B, then a small b. If I will say 21A, 31A, 31B, 31C, then capital letter. It means they have been added by an amendment to the Constitution. Now another basic thing that we need to understand is the types of majority mentioned under the Indian Constitution, because when you read the newspapers, these things comes, that is, this majority is not there with the government in this house, that house, and in the later classes also I will be telling you. So you will have an idea that okay, sir has said simple majority, this is the simple majority. First of all, simple majority. simple majority is more than 50% of the members present and voting. More than 50% of the members present and voting. For example, suppose in the Lok Sabha, we have a strength of, total strength is 543 members. All the members are not present in the house daily. Suppose on a particular day, 500 members are present in the house, and during the voting also, all the members are not compelled to vote. They are not compelled to vote. It is your wish. I will not vote. So, even if you are present in the house and you are not voting, it is termed as abstention. Suppose 40 members abstain out of 5, means abstain means you are present in the house but you are not taking part in the voting. So, here present and voting will be 460. 460 present and voting. So, simple majority here will be 460 divided by 2 plus 1. It is more than 50%. That is why plus 1 is there. More than 50%. Otherwise, it will be a tie. So, you see, we are not bothered about those who are present in the house and those who are not voting. You are present in the house and you are voting, then only your voice will matter. Otherwise, you are a useless person now for this purpose. This is the easiest majority required under the Indian Constitution. It is also termed as working majority. Now, for those who may not have understood it, I will take another attempt so that you will be able to understand it. Suppose in this class, 25 of the students, they are present. It is a hypothetical situation, and I will ask you a question that how many of you want to have a holiday tomorrow? It is a hypothetical question. There will be a class tomorrow. So, if I ask that how many of you want a holiday tomorrow, out of 25, 5 of you will say, sir, we will not take part in such type of voting. If there will be a class, we will come, otherwise we will not come. So, 5 of you, what you did? What you did? You abstain. Clear? This is the meaning of abstention. You are present in the house, but you have not taken part in the voting. So, how many of you are present as well as voting? 20. So, what will be the simple majority here? 11. So, this is the easiest majority required under the Constitution of India. Now, here you can write as note, N-O-T-E. Wherever the Constitution is silent, wherever the Constitution is silent, on the type of majority required, comma, it is assumed that simple majority is required. So, you will not ask, sir, why you said that simple majority is required if it is written anywhere? No, it is not written anywhere. That is why simple majority is required. So if it is just written that it has to be passed by the house, it has to be passed by the house, means simple majority will be required here, because for any other type of majority it will be clearly mentioned that 2/3 of the members present and voting, 2/3 of the total strength of the house. So if any other majority will be there, it will be clearly mentioned. But where it is written that it has to be passed by the house, then simple majority will be required. Then coming to the second type of majority, it is absolute majority. Absolute majority is more than 50% of the total strength or membership of the house. It is fixed. It is also termed as majority of the house. This is fixed because it is more than 50% of the total strength or membership of the house. In the Lok Sabha, it will be 543 divided by 2 plus 1, that is 272. Then in the Rajya Sabha, it will be 245 divided by 2 plus 1. In the UP State Legislative Assembly, it will be 403 divided by 2 plus 1. In the Delhi Legislative Assembly, it will be 70 divided by 2 plus 1. In Haryana Legislative Assembly, it will be 90 divided by 2 plus 1. In Jharkhand, it is in the Jharkhand Legislative Assembly, it will be 81 divided by 2 plus 1. It is fixed. In Rajasthan, it will be 200 divided by 2 plus 1, because the strength of the assembly is 200, the strength of the assembly is 90, 81, like this. Now, this majority is required for government formation. This majority is required for government formation. You see, we are having elections in the state of Jharkhand and Maharashtra. So, a political party or a pre-poll coalition, if it is able to get more than 50% of the seats of the assembly, that political party will form the government in the states. At the central level, you see, the NDA, that is the National Democratic Alliance, it has got more than 272 seats. So that is why it is in the government today. In Telangana, we have the Congress government, because the Congress got more than 50% of the total seats. In Andhra Pradesh, we have the Telugu Desam Party's government. Why? Because the Telugu Desam Party got more than 50% of the seats in the Legislative Assembly. In Delhi, we have got the Aam Aadmi Party, which is in the government, because Aam Aadmi Party got more than 50% of the seats in the Legislative Assembly. So this majority, नहीं बोलते हैं कि अरे this party has not got the majority, it has no majority in the house, means more than 50% of the members, that is the total strength of the house. This is your absolute majority. Then Third type of majority is effective majority. Effective majority is more than 50% of the effective strength or the then strength of the the then strength of the house in absolute majority. It was more than 50% of the total strength, the total membership. Here what we have written, effective strength or the then strength of the house. Now what is this effective strength or the then strength? Is equal to strength of the house minus the vacancies. Here the vacancies will not be counted. Earlier here you see that we had counted the vacancy, 543 means 543, but here the vacancies will not be counted. For example, Rajya Sabha. In the Rajya Sabha, the strength is of 245 members. This is the total strength. This is the number that we had taken in case of absolute majority. But here suppose two members may have died. Three members may have resigned. So these seats are vacant seats. These seats are vacant seats. Elections have, by elections have not taken place. So 5 vacancies are there. Effective strength will be 245 minus 5. It will be 240. And here the majority will be 240 divided by 2 plus 1. Here we are not supposed to count the vacancies. That is the effective strength, the then strength of the house. So in case of absolute majority we had taken this number 245, but here the vacancies will not be counted. Yahan pe we had taken the vacancies also, here the vacancies will not be counted. Now the question here is where this majority is required, because absolute majority will be required for the formation of the government. Simple majority is required wherever the constitution is silent on the type of majority required. But here where this majority will be required, you can write it. This majority is required first in the Rajya Sabha for the passage of a resolution for the removal of the vice president. So if the vice president of India is to be removed, then this majority will be required in the Rajya Sabha. When I have said Rajya Sabha means Rajya Sabha. When we will be using the word parliament, it means both the houses of the parliament. So suppose Sri Jagdeep Dhankad is to be removed, then the resolution has to be introduced only in the Rajya Sabha. After the Rajya Sabha will discuss it, it will pass it by this majority, effective majority, and then it will be transmitted to the Lok Sabha, which has to pass it or approve it by a simple majority. So the effective majority will be required in the Rajya Sabha only. That is what we have written. Secondly, for the passage of resolutions in the concerned legislatures for removal of their presiding officers in the Lok Sabha and in the state legislative assemblies the speaker and deputy speaker, they are the presiding officers. Then in the Rajya Sabha and the legislative councils, the chairman and deputy chairman are the presiding officers. Now suppose if the speaker of the Kerala Legislative Assembly is to be removed, then this majority will be required in the Kerala Legislative Assembly. If the chairman of Maharashtra Legislative Council is to be removed, this majority will be required in the Maharashtra Legislative Assembly. If the speaker or deputy speaker of any of the other assemblies have to be removed, it will be this majority will be required in that state assembly. For example, in the month of February this year only 2024, a resolution was passed to remove the speaker of the Bihar Legislative Assembly, and it was passed by this majority, that is the effective majority of the house. So as now the things may be clear to you, as the vice president is the chairman of the Rajya Sabha, so effective majority is required in the Rajya Sabha for the passage of a resolution for its removal. As he is the vice president of India, the formality is that it has to be approved by the Lok Sabha. But here, so wherever you will find effective majority, then your answer will be the presiding officers, speaker, deputy speaker, chairman, deputy chairman, they are termed as the presiding officers. So till now we have discussed the simple majority. It is more than 50% of the members present as well as voting. Those who are not present in the house, even though those who are present in the house but are not taking part in the voting, we are not going to consider them. Then absolute majority, it is more than 50% of the total strength or membership of the house, and effective majority, here we have taken into consideration the effective strength, the vacancies are not to be counted here. Now coming to the fourth type of majority, that is special majority. There are three types of special majorities. First, not less than two-thirds of the members present and voting. It is not less than. For example, suppose in the Rajya Sabha, we have a strength of 245. Out of that, present and voting 230. So, here this majority will be two-thirds of 230. In simple majority, it was 230 divided by 2 plus 1. But here it is two-thirds of 230 because it is not less than, means even two-thirds will also do. That is why it is two-thirds of 230. So, this majority is required at some places. That I will be discussing with you when I will be discussing the parliament with you, because it is our second class only and many things can be bouncer also if I discuss the more technical parts. So, gradually till the time we will be reaching the topic of parliament, obviously we will develop an understanding so that the things will be easier for you to understand, or I will make you to understand at that point of time, and I will tell you that yes, I had told you in the initial lectures that where it is used. So, this is the first type of special majority, not less than two-thirds of the members present as well as voting. Then coming to the second type of special majority, here two conditions have to be fulfilled. Yes, hold. Let the staff come, I will tell. Here two conditions have to be fulfilled. Two conditions have to be fulfilled here. First, more than 50% of the total strength or membership of the house, that is absolute majority, and not less than two-thirds of the members present and voting. So here both the conditions have to be fulfilled. It is not either or. So it is majority of the house, that is the first one, absolute majority, and the second one is not less than 2/3 of the members present as well as voting. Now, let us take a condition when a bill has been introduced in the Lok Sabha which needs this majority, and in the Lok Sabha, suppose the members who are present and voting is 400. Suppose 400 members are present as well as voting. So here first condition 272. The second condition not less than 2/3 of the members present and voting. So here what will be the 2/3 of 400? What will be? थोड़ा और आसान कर दूं आप. What will be the 2/3 of 450? You will have to appear in CSET also. 300, yes. So suppose, so 300 is the 2/3 of 450. So both the numbers are required here. It is not that 272, it is 300. So if 300 members out of 450 who are present and voting, they vote in favor of the bill, both the conditions are being fulfilled. 300 is more than or equal to 272. Then suppose if when 450 members are present and voting, suppose 298 members, they vote in favor of the bill, if the bill will be passed or not? If the bill will be passed or not? No. This condition has been fulfilled, but the second condition has not been fulfilled. 298 is not the 2/3 of 450, so the bill will not be passed. Both the conditions have to be passed. Minimum, this is the requirement, but apart from it, it should be not less than 2/3 of the members present as well as voting. Now the flip side of it. Now 400 members are present as well as voting. What will be the 2/3 of 400? 266. Sure. 267. Because 266.66 होगा, आदमी है, individual को you cannot cut. So the next number will be taken. So 267. Now suppose out of 400 members who are present as well as voting, 270 members are voting in favor of the bill. If the bill will be passed or not? No. No doubt 270 is the 2/3 of 400, or it is more than that, but this majority is not there. This majority, so both the conditions have to be fulfilled here. It is not that only one condition will be fulfilled or this condition. So this bill will not be passed because the conditions are not there. Apart from it, if I ask you another question, that suppose if 272 members are present and voting in the house, okay, 272, then how many members should support the bill to get it passed? Present and voting is 272 in this case. How many members should vote in favor of the bill? All of them. All of them. Then only both the conditions will be fulfilled. So it is a tough majority. Minimum you need to have this number. that is the absolute majority plus this number also. So, where this majority is required, obviously it will be required for some tough work. So, this majority is required, you can write it. First, under Article 368, for the passage of a constitutional amendment bill in both houses of the parliament So, when we say in both the houses of the parliament, means sitting separately in the Lok Sabha as well as in the Rajya Sabha. So, if the Lok Sabha will pass the bill by this majority and if the Rajya Sabha will not pass the bill by this majority, the constitution amendment will not take place. So, this majority is required for the amendment of the constitution. Then, secondly, for the passage of resolution in both houses of the parliament for the removal of the judges of the Supreme Court and High Courts the Comptroller and Auditor General CAG, then Chief Election Commissioner and State Election Commissioners. So, to remove these constitutional officers, the majority, this special majority will be required in both the houses of the parliament. Then, thirdly, in a state legislative assembly for the passage of a resolution requesting the parliament to create a legislative council in the state or to abolish an existing one. So, here basically when we talk about the third point that we have written, this majority will be required in the state legislative assembly. Why? If a state wants to have a legislative council, then the initiative has to be taken by the legislative assembly of that state. For example, how many of you belong to the states where we do not have the legislative council? How many of you? You are from Himachal Pradesh. Okay. Punjab, MP. ठीक. So, suppose we want to create or we need to create a legislative council in the state of Madhya Pradesh. So, if we wish to have a legislative council in Madhya Pradesh, so the Madhya Pradesh Legislative Assembly to pass a resolution by a special majority, the majority that we are discussing, requesting the parliament to create a legislative council. So, the Madhya Pradesh Legislative Assembly will pass a resolution and it will request the parliament to create a legislative council. So, that resolution of the Madhya Pradesh Assembly has to be passed by a special majority. And then it finally depends on the parliament, and in the parliament simple majority will be required. I will be discussing this aspect again when I will be discussing the state legislature with you. Since we are discussing majority and I mentioned some questions can be there, what the teacher has written. So, it is this point. Another example, suppose if a state has got a legislative council, it wants to abolish it. So, the request has to come from the legislative assembly of that state only, and the request, the resolution has to be passed in the assembly by this majority. Whether to create or abolish, it completely depends on the parliament, but the initiative has to be by the assembly of the state. Andhra Pradesh State Legislative Assembly had passed a resolution requesting the parliament to abolish the legislative council, but the parliament said nahi, will not do that, because उस time पे फिर after that the pandemic had come. So then Gujarat Assembly had also requested that we want to have a legislative council. Even Odisha Assembly had also passed a request, but obviously when that was an era of pandemic, that is why the parliament was not functioning full-fledgedly, only the important parliamentary works were being done. So this is the third point that you have written, that is in the state legislative assembly. So where this special majority will be required? First, for the amendment of the constitution under article 368. Second, if the judges of the Supreme Court and High Court to be removed, if the chief election commissioner to be removed, if a state election commissioner to be removed, and if the CAG is to be removed, the resolution has to be passed by both the houses sitting separately by this special majority, and here in the state legislative assembly. Coming to the third type of special majority, it is under article 61. that is impeachment of the president. Here it is not less than two-thirds of the total strength or membership of both houses of the parliament sitting separately. In the Lok Sabha, it will be two-thirds of 543. In the Rajya Sabha, it will be two-thirds of 245. It is the toughest majority that is required under the Constitution of India. That is two-thirds of the total strength or membership. Whether you are absent, you are present, it hardly matters. Now, one more thing I will tell you here as part of your basics. You see that the word impeachment has been used in the Constitution only for the president, not for any other official. But we have seen that in the loose terms, the word impeachment is also used in case of the judges of the Supreme Court and the High Court, even for the CAG. Now, if someone will ask you a question that what is the difference between impeachment and removal, whether a judge of the Supreme Court is removed or he is impeached. So, you should say that technically speaking, as per the Constitution of India, the word impeachment or impeachment is the process which is used only in case of the president. Only in case of the president. Rest all are removed. You see, what is difference between impeachment and removal here? Impeachment is a special legislative process. It is not a normal legislative process. It is a special legislative process. And just as both the houses of the legislature pass the resolution, automatically the concerned person stands removed. No formal removal is there. Suppose if two houses are there, and if I am the president, if both the houses will pass the resolution by this majority, I will stand impeached. I will stand impeached. But when we talk about removal, removal is an executive order. It is an executive order. You see, Article 124 clause 4 says that a judge of the Supreme Court to be removed by the president, upon the passage of a resolution by both the houses of the parliament by a majority of the house as well as two-thirds of the members present and voting on the grounds of proved misbehavior or incapacity, removed by the president. When the president will remove? If both the houses of the parliament will pass the resolution by special majority, that is the majority of the total membership of the house and two-thirds of the members of that house, then two-thirds of the members present and voting. तो ये हो गया. So you say that it is removal, but Here the grounds are also different. For the impeachment of the president, it is violation of the constitution. For the impeachment of the president, it is violation of the constitution. For the removal of the judges, it is proved misbehavior or incapacity. But even then, in loose terms, we have seen that the word impeachment is used even for the judges also. Even in the UPSC question paper, I had seen impeachment of the judges. Even the Supreme Court also uses the term impeachment of the judges. Here, it is in the context. It is in a context. In social sciences, the context is also important. What is the context here? The special power that has been given to the parliament, the role that is played by the parliament is important here. Until and unless the parliament will not pass the resolution by special majority, the president cannot arbitrarily remove a judge of the Supreme Court or the High Court. So, the main role is that of the parliament. It is because of that reason that we use the word impeachment even for the judges of the Supreme Court, High Court, the CAG, the Chief Election Commissioner and the State Election Commissioner also. It is in the context. So, that is not wrong also. But if you are asked, so you should clarify that sir, impeachment under the Constitution of India has been used only for the president, but for rest it is the removal. It is the removal. Then they will ask you, the board may ask you, okay, it's all right, but what is the difference between impeachment and removal? And if when you say okay, impeachment and removal, they can ask you that okay, it's all right. So, but why the word impeachment is in loose term used for the judges? So, you say that sir, it is in the context. The important role that is played by the parliament, that is taken into consideration. Until and unless the parliament will not pass the resolution, the president cannot remove a judge of the Supreme Court or the High Court. So, these were the types of majority under the Constitution of India. Sometimes the students say, sir, for amendment of some of the provisions of the Constitution, 50% ratification by the state is also required. Yes, that is there, but here what we are discussing, the types of majority under the Constitution of India. It is what is required in the houses of the parliament or in the legislature. That is also a majority that we will also be discussing. So, simple majority, then absolute majority, effective, and then three types of special majority. Now coming to another basic thing that we need to discuss, it is the salient features of the Indian Constitution. Now here, when we say salient features of the Constitution, there are two approaches. One approach is the one-day examination approach, SSC, Bank PO, one-day examination approach. The other approach is the civil services approach, a broader idea. In the one-day examination approach, what we see? Two sentences are there. Longest constitution, written constitution, it has been taken from under this we can say various constitutions. But here basically we will be focusing not on too much of points, because our syllabus is very specific here. We need to stick to our syllabus. In the syllabus of the preliminary examination that most of the students have never seen, they look into only paper 1, paper 2, paper 3, paper 4. जैसे कि कल ही वो मेंस ही देने लगेंगे. They will not be appearing in the prelims examination. They focus on only on that aspect, most of the students. paper 1, paper 2, paper 3, paper 4. But they forget that there is something called preliminary examination also, and they need to crack it. Then only they will be appearing in paper number 1, paper number 2, paper 3, paper 4 optional, and essay also they will be writing. So, in the preliminary examination syllabus, it is mentioned political systems. It is mentioned political systems. And then in the syllabus of the main examination, it is mentioned comparison of the Indian constitution with world constitution. So it is not feasible on our part to read each and every political system in detail. It is not feasible also. So while discussing the features of the Indian constitution, if some other pattern is followed in the other countries, we need to look into that from that. It is not that you will have to read all the constitutions of the world. You will have to do a smart work here. Now here, the first salient feature of the Indian constitution is that it is a written constitution. Now herein, we will use a comparative approach. In some of the countries, there is unwritten constitution. So we need to develop an understanding of the difference. Now when we talk about a written constitution, here you can write it. A written constitution is that constitution the provisions of which, I repeat, a written constitution is that constitution, the provisions of which are codified, that is, systematically arranged in a single document. So codification means systematic arrangement in a single document of all the provisions, that is codification. Now when we say an unwritten constitution, here you can write an unwritten constitution does not mean that the provisions have not been written down, but are not codified or systematically arranged, in a single document. Sorry. China, France, US, India, etc. are some of the countries where we have got written constitution. When we talk about unwritten constitution, United Kingdom, New Zealand can be the examples where we have got unwritten constitution. Now, you see that you can exactly say that this document is the Constitution of India. This document is the Constitution of United States of America. This document is the Constitution of China. But you cannot say that this document is the Constitution of United Kingdom. This document is the Constitution of New Zealand. It does not mean that the things have not been written down. They are there, but not at one place. For example, if we talk about the Indian Constitution, the provisions related to the citizenship, creation of new states, rights of the people, then what are the duties of the state, directive principles of state policy, duties of the citizens, it has also been mentioned. Then the provisions regarding the union government, state government, local self-government, center-state relations, tribunals, elections, civil services, everything has been mentioned at one place. But here, in case of an unwritten constitution, the things have been written down, but not at a particular place. There are different statutes. For example, there is a different book on the parliament, the parliamentary acts, then judicial act. The laws related to judiciary are there in the separate statute. A statute means the laws which are passed by the parliament or by the legislature, statutes. So different statutes are there. So you cannot say that this document is there, the Constitution of UK, but things have been written down here and there. That is what we have written. Then secondly, a written constitution is an enacted constitution, whereas unwritten constitution is an evolved constitution. A group of people sat together, they wrote the document called the Constitution and then said, this is the Constitution of this country. The members of the Philadelphia Convention, they sat together. Philadelphia Convention is the body which enacted the Constitution of United States of America. So the Philadelphia Convention, it enacted the Constitution of America. In case of India, we had the Constituent Assembly. The members sat together, they finished the writing of the Constitution. This is the Constitution of India. At one stroke, they wrote and then their work was over. But when we talk about an unwritten constitution, it is an evolution. At one point of time, it is not that the people sat down and wrote all the laws, but some laws were made 200 years earlier, some were made later 50 years later on, 100 years later on, and they are continuing even today. Here you can write the example. The British Constitution has been evolving since 1215 AD. Since 1215 AD, that is the time of Magna Carta. The time of Magna Carta. Magna Carta was a decree of the king, and the king in 1215 AD, because of the pressure also, he had given some rights to the people, like I will not punish anyone without hearing him or her, I will treat everyone equally. So many of the aspects which were there in the Magna Carta, they are present even today. So it has a gradual evolution. The new law is made, the earlier law all ceases to exist. Khatam ho jata hai apne aap, ceases to exist. So this is an evolution. No doubt every country's constitution evolves with time, but here there is no rules and regulation. A new law you will make, the earlier law will cease to exist. But here, even the changes have to be made in accordance with the provisions which have been written down in the constitution. You cannot do it arbitrarily, because we have got article 368 in the constitution, which says that the parliament has the power to amend the constitution, because no constitution can remain static one. You need to be dynamic, because change is the only unchanging reality of this world. So, with the changing times and circumstances, obviously the provisions of the constitution also needs to be amended, but the process how that will be done has been mentioned in the constitution itself, which is enacted by a separate body. Then third and the most important aspect, that in a written constitution there is supremacy of the constitution. Why we say that there is supremacy of the constitution? Because all the three organs of the government owe their origin and derive their authority from the constitution. Sometimes the students, they say, sir, in our country the judiciary is supreme. Why they say? Because the judiciary in our country, especially the higher judiciary, has the power to declare the law made by the legislature as well as a decision taken by the executive as null and void. So, the general understanding may be that judiciary is supreme, but no, it is the constitution that is supreme. If someone will ask you who is supreme in democracy, obviously the answer will be people. People are supreme in democracy, but here the constitution is supreme. Why? Because it is the constitution which has given the power to the judiciary, that is to review even the laws made by the legislature. So, it is the constitutional supremacy. Then when we talk about this part, that is the unwritten constitution, it is the supremacy of the parliament. Now here, when we say supremacy of the parliament, you see, where there is written constitution, the powers of the parliament are defined, that the parliament will make laws on these subjects, and this will be the process that will be followed by the legislature, it is mentioned. But when the things have not been written down, the parliament itself makes laws, obviously it is the supremacy of the parliament, because no constituent assembly, nothing, so you make your own laws. So the parliament makes laws related to judiciary, the parliament makes laws related to legislature, it makes laws related to executive, and there is nothing called judicial review in United Kingdom. And the United Kingdom's parliament, the British parliament, can make laws on any subject. It can change a law by a very simple process. Our process is mentioned in article 368. They have no written constitution, nothing has been written down. You can change as and when you want. So there is parliamentary supremacy in the United Kingdom. So here you can write as note, the parliamentary supremacy, as it exists in United Kingdom refers to the supreme lawmaking power of the British Parliament, full stop. The British Parliament can change any existing law by a simple process full stop. It can make a law on any subject. It can make laws on any subject, and the laws made by the Parliament cannot be challenged before any authority and cannot be declared as null and void. Full stop. According to some scholars, who have analyzed the British Parliament, the British Parliament is so powerful, that it can make laws on any subject. Except on changing a man into a woman and a woman into a man. Except on changing a man into a woman and a woman into a man. Basically, the unwritten constitutions are very much based on the commentaries by the scholars also. So if you have read political science, then in the comparative politics we studied, and when we talk about the British Parliament, we have got many commentaries by the eminent, we can say, scholars. For example, Lasky has also commented, Bagehot has also commented on, we can say, this cabinet system, what type of system they are. So the scholars who have analyzed the British Parliament, they have said that the British Parliament is so powerful that it can make laws on any subject which is naturally possible. Changing a man into a woman and a woman into a man is not naturally possible. So you cannot make a law on that. So, but on all other subjects you can make a law and your law cannot be challenged. Such type of questions are asked in the main examination. I'll tell you the question when I'll be discussing the parliament with you, because when we talk about the Indian parliament, that whether the Indian parliament is sovereign or not. Now, when we talk about the lawmaking aspect, there is supremacy of the parliament in the lawmaking with respect to legislature and the judiciary, with respect to it. But when we talk about sovereignty of the parliament, the Indian parliament is not as sovereign as the British parliament. The British parliament can make laws on any subject, but in our country, there is a constitutional supremacy. The provisions of the constitution are there, and if the parliament makes a law which is not in accordance with the provisions of the constitution or against the basic spirit of the constitution, that is termed as the basic structure of the constitution, the judiciary has been given the power. Judiciary means the Supreme Court has been given the power to declare it as null and void. So, such type of competitive questions are asked in the main examination. तो एक तो अभी मैंने आपको आज लिखवा दिया. When I will be discussing with you the parliament, the first question that we'll be discussing is whether the Indian parliament is sovereign or not. So, comparative questions you will be able to answer them. This was the first salient feature, and from here, from May's point of view, in India there is supremacy of the constitution, and in Great Britain there is supremacy of the parliament. So, wherever we have got unwritten constitution, there is supremacy of the parliament. Here it is supremacy of the constitution. In the last class also I had told you, it provides for a limited government, restricted government. Now, coming to another feature of the Indian constitution, it provides for a parliamentary system. You see, when we talk about parliamentary system, here parliamentary system will not mean that there is a parliament in the country. Basically, it is a political system. Across the globe, the countries have either adopted parliamentary system or they have adopted presidential system. So, what is the basis of this differentiation? So, here we will be discussing parliamentary system as well as presidential system also. So, one sentence you can write to start with: based on the relationship between the executive and the legislature, political systems have been classified as parliamentary and presidential. This class lecture notes should be like a textbook for you, because in the textbooks obviously many here and there things are there, but it is a very, we can say, okay, the teacher was discussing it, तो अचानक से अच्छा, why the teacher started discussing presidential system? Then what is the logic? Why we have got this differentiation between the parliamentary system and presidential system? What is the basis? So, in a particular country, what is the relationship between the executive and the legislature in a particular country? Based on that, we have either the parliamentary system or a presidential system. Now, one by one we will be discussing it. First of all, coming to this parliamentary system. You see, in a parliamentary system, there are two heads. head of the state and head of the government. The head of the state is the nominal head and the head of the government is the real head. For example, United Kingdom. In the United Kingdom, the crown is the head of the state and the head of the government is the prime minister, who is the real head. If we talk about India, the president is the head of the state and the prime minister is the head of the government, who is the real head. Now you can ask me a question that, sir, if the prime minister is the real head, then why it is not termed as a prime ministerial system? Why it is not termed as a prime ministerial system? Why parliamentary system? The logic here is that the head of the government is a member of the parliament, means the parliament provides for the head of the government. So if we talk about the British Prime Minister, he must be a member of the House of Commons. So the members of House of Commons, they are known as members of the parliament. Then in India, our Prime Minister must be a member of either the Lok Sabha or the Rajya Sabha. So now you say, sir, in different countries, we have got different nomenclatures for the legislature. Why only parliamentary system? Because such a system evolved in the United Kingdom. The United Kingdom is known as the mother of parliamentary democracy. And in United Kingdom, the legislature is known as the parliament. So as the system evolved there, that is the crown, means the king or the queen, he will be the nominal head. The real head will be the prime minister, who will be the representative of the people. So he must be a member of the parliament. Such type of system evolved in the United Kingdom, and there the legislature is known as the parliament. So the parliamentary system, that is why the nomenclature parliamentary system. So this is the first important aspect with respect to the parliamentary system. Then second point you can write here. The members of the executive that is the ministers must be the members of the legislature. You see, in our country, all our ministers, they are either the member of the Lok Sabha or the Rajya Sabha. You must be the member of the legislature. Not only this, in our country, we have got a law that a non-member can be a minister for 6 months. But within 6 months, he needs to get elected to either house of the legislature. This pattern is followed at the state level also. And thirdly, the executive is responsible to the legislature, especially to the lower house. To the lower house. Lower house is the popular house. Lok Sabha in our country, House of Commons in United States of United Kingdom. So these are the 3 points that you need to remember. UPSC is very fond of asking questions every alternative year on parliamentary system, that which of the following is correct or incorrect about the parliamentary system. These 3 points you need to remember from the examination point of view. Those who may not have understood it, I will try to make the things easier with the help of an illustration. In the parliamentary system, the electorate means the voters. If our name is there in the voters list, we are the electorate. So the electorate, it elects the members of the legislature. We do not elect our prime minister. We do not elect our ministers. What we do in the elections? We just go and vote, and if we wish, we wish to see that okay, this person should be our representative, we go and vote for that person. So we elect the members of the legislature only. We do not elect. Even a person can be defeated also, he may not become a prime minister or the chief minister. So the electorate elect the legislature, and the party which gets the majority in the lower house, that is the popular house, its members becomes the members of the executive. Here we are talking about the political executive, that is the ministers. So all the members of the executive, that is the ministers, they must be the members of the legislature, but it is not the vice versa. It is not vice versa, means all the members of the legislature will be the members of the executive. No, only some persons will be appointed as the ministers. So you see that the legislature provides for the executive. The second point that you had written here, that is the members of the executive, that is the ministers, must be the members of the legislature. No, they are not responsible. Criticism is a different thing. Criticism is a different thing, but a no confidence motion against the government can be passed only in the lower house, that is in the Lok Sabha, and at the state level in the legislative assemblies. Criticisms can be there. They can criticize the policies of the government, not a big deal. But basically, when we say here responsibility, accountability, it means that is who can remove them for the failure of their policies. So here it is a fusion of the executive and the legislature. You see your ministers, external affairs minister, he is a member of the Rajya Sabha, but he will be sitting in the Lok Sabha also, he will be answering the question also. But you see your ministers, they are the members of the executive, but during the discussions they are the members, they become the members of the legislature also. They take part in the discussions, deliberations in the house. There is a fusion between the executive and the legislature. And the third point that we have written is the executive is responsible to the legislature. Now, in the preliminary examination, obviously if the word is responsible to the legislature and it is not clearly mentioned responsible to the lower house, then it will be responsible to the legislature. But if it is mentioned that is the executive is responsible to the lower house, that will be the correct option, because lower house is the popular house. Lower house is the popular house, that is why. Because in almost all the countries we do not have a bicameral legislature. Only in some of the countries we have got bicameral legislature. So everywhere the popular house has got more powers in this regard. And in our constitution there is Article 75 clause 3 which says that the Council of Ministers is collectively responsible to the Lok Sabha, because that is the popular house. A no confidence motion can be introduced and passed only in the Lok Sabha. So basically you see, this is, we can say, the responsibility. Now these 3 points you need to remember. Now coming to the presidential system. In a presidential system, the head of the state and government is the same. In our country, you see, all the decisions are taken by the Council of Ministers and the president is the signing authority. But in America, all the executive decisions are taken by the American president and he is the signing authority himself. Then second point, a member of the executive that is a minister not to be a member of the legislature. There is a strict separation of powers between the 3 organs of the government. So in America, basically the president as well as the other ministers, they are not to be the members of the legislature. For example, you see Donald Trump is now the president elect, and after he will take oath on 20th of January next year, he will constitute his own minister, we can say the council, and he will be appointing secretaries. Just as we have ministers in India, and in America they are termed as secretaries. And if a member of the Senate or House of Representative will be appointed as the minister, means the secretary, he will have to resign from the house. Then only he will be taking oath as the secretary or as a minister. You cannot be a minister as well as a member of the legislature at the same point of time. There is a clear-cut separation of powers. But in our country, if you are a minister, you must be a member of the legislature. You will be taking part in the legislative process also. There we will be doing the executive work, you do the legislative work. With the help of an illustration, I will explain it. The US case, the US is a role model of a presidential system. In the US, the electorate elects the members of the legislature that is the members of the Senate and House of Representatives. The members of the Senate are elected every 6 years and the term of the House of Representative is 2 years. It is just like our Lok Sabha. It is just like our Rajya Sabha. Then in separate election, the chief executive is elected. That is, the US president is elected every 4 years. In our country, what we had discussed in a parliamentary system, the party which will have majority in the lower house, its members will become the members of the executive. But here it is not like that. The American president will be elected in separate election, and the American president is not dependent on the legislature for its survival. In our country or in a parliamentary system, if you have got the support of the lower house, majority in the lower house, you will be in the government. Here it is not the case. Suppose in the House of Representatives election, what is the political party of Trump? Republican. Suppose the Republican party loses its majority, it has no majority in the House of Representatives, it will have no effect on the term of the American president. So both have to work separately, and the chief executive, that is the American president, will appoint the secretaries, the ministers. They must not be the members of the legislature. They must not be the members of either the Senate or the House of Representatives. We have got many instances when a senator is appointed as a minister or a secretary and he resigns from his membership of the House. So these were the things that we needed to discuss in today's class. That is the basic idea I have given. In tomorrow's class, basically I will be taking up for discussion the same aspect, because we have written this concept, separation of powers. How this concept of separation of powers works in the US and in other countries. Then another we can say set of we can say the government is there in some of the countries, like a blend of parliamentary system and presidential system, like in France, in Russia, in Sri Lanka. There is a blend. They are known as quasi-presidential system. So we will be discussing this concept, that is, what is quasi-presidential system, what is the French model, what is this concept of separation of powers. Have it बोलो. हाँ, that is what tomorrow we will be discussing. इसीलिए आज मैंने नहीं किया, आज खाली आपको बेसिक्स बता दिया. Tomorrow we will be discussing what is this concept of separation of powers, how it exactly works, what is this concept of checks and balance. ये in detail we will be discussing in tomorrow's class.